Thank you all for joining us this morning when we're going to be talking about governing law and jurisdiction clauses in insurance contracts and why they are crucial. My name's Tom Grant. I'm a senior associate in our national insurance disputes team at Mills and Reeve. I'll be speaking today with Dan Pearson, who's an associate in the same team. Today's session is all about governing law and jurisdiction clauses in insurance contracts. But what are they and why are they important? Dan.
Thanks, Tom. So what are governing law and jurisdiction clauses? Essentially, governing law clauses determine which country's laws will apply to the interpretation of the insurance contract. And this is key should any dispute arise between the parties to the contract. So, for example, where the governing law is England and Wales, English and Welsh law will apply to the interpretation of the contract wording and how any disputes are decided. Jurisdiction, on the other hand, relates to the actual geographical location where a dispute between the parties in relation to the contract will be heard. So if the governing law of the contract is England and Wales, we might expect the courts of England and Wales to have jurisdiction, and it often does, but not always. Instances do arise where the two are different, which results in an inconsistency between governing law and jurisdiction, and we will discuss later why that can cause problems. But why are they so important? Separately and together, the inclusion and specific contents of each clause are vital. As with any contract, the parties must be alive to ensuring that there is an appropriate system of governing law in play should a dispute arise, and that the location of where any dispute will be heard is appropriate. Get the first wrong, and the parties may have a flawed or at least unpreferred system of governing law applying to the contract and the dispute. Get the second wrong, and even if there is a preferred system of governing law applied, the location of the courts may result in delays, lack of judicial understanding of the law in play, or an unfavourable decision being reached. In absence of express clauses, complex issues can arise as to how disputes are dealt with and where they are decided. And whilst there are principles which are intended to provide guidance on how governing law and jurisdiction are decided, for example, the Rome Conventions and the Brussels regulations, which we're not discussing today, anyone with experience of those will know that they are extremely difficult to navigate. And where issues do arise, preliminary disputes to resolve those can be time-consuming and extremely expensive in their own right before the parties are able to address the actual substance of the dispute. And these issues can hopefully be avoided from the outset by ensuring that there are carefully worded clauses incorporated into insurance contracts.
Okay, so having established what they are and why they're important, we're now going to have a closer look at the importance of really clear drafting when it comes to governing law and jurisdiction clauses. Insurance contracts are, after all, contracts like any other, so it's vitally important to use really clear and unambiguous language which reflects the agreed position of the parties. Now, I appreciate that sounds like a bit of a truism, and it is to an extent, but as we all know, the authorities are littered with examples of unclear drafting that's been interpreted differently by the parties and ultimately ended up in court. An example of this in the context of governing law and jurisdiction clauses in insurance contracts can be found in the recent Court of Appeal decision in Almanna Lifestyle Trading LLC and United Fidelity Insurance Company PSC. In that case, the policyholder ran a large hospitality and retail business in the Gulf region. Policies were issued in the UAE, Kuwait, and Qatar with a governing law and jurisdiction clause, which we will now bring up on screen. Now, a quick spoiler alert, we're talking about the importance of really clear drafting, so what you're about to hear is not that, so bear with me. Applicable law and jurisdiction in accordance with the jurisdiction, local laws and practices of the country in which the policy is issued. Otherwise, England and Wales UK jurisdiction shall be applied. Under liability, jurisdiction will be extended to worldwide, excluding USA and Canada. Now, perhaps unsurprisingly, it was agreed by the parties and the court that this was by no means a model of good drafting, but nevertheless, the policyholder tried to bring claims for business interruption losses during the COVID pandemic in the English courts, where the interpretation of the jurisdiction element of the clause was disputed by the defendant insurer. Now, we thought it'd be interesting to run a poll because, as you can see on the slide, there ended up being two very different interpretations of the jurisdiction element of the clause, which we've set out here. One is the interpretation of the commercial court at first instance. The other is the decision of the Court of Appeal. So, which of these do you think is the correct interpretation of the clause? A, that it gave the policyholder a choice between bringing a claim in its local courts or in England, or B, that it made the English courts a fallback option for jurisdiction only if local courts in the Gulf region could or would not accept jurisdiction. I believe a poll should have opened up for you to enter your decision. And if everyone has voted, we can reveal the answer on the next slide. So at first instance, the commercial court held that the clause provided for English courts to have non-exclusive jurisdiction as an alternative to the local courts. The word otherwise in the clause was essentially taken to mean alternatively. However, that was overturned by the Court of Appeal, who held that the clause only provided for the English courts to be a fallback option for jurisdiction if local courts could or would not accept jurisdiction. Now, as we can see, a comfortable majority of our obviously very well-informed audience agreed with the Court of Appeal's interpretation. So we can all give ourselves a collective pat on the back for that. Well done. Ultimately, the case shows how even the courts can interpret the same words very differently where there's any ambiguity, and it underlines the point we're making about the importance of clear and express choices of governing law and jurisdiction. I mean, as we can all imagine, the cost of running that case to the Court of Appeal will have been immense on an issue which could have been avoided entirely if some more careful thought had been given to the drafting of the clause. Now, although the Almana case related to jurisdiction, the same principles do apply in relation to choice of governing law clauses. For example, a clause specifying US law can give rise to uncertainty because in a federal system like the US, it should really identify the laws of a particular state which will apply, usually by reference to where the policyholder conducts its business or is headquartered. Similarly, with UK law, it's important to specify the law of England and Wales or Scotland. Ultimately, these should be straightforward issues to clarify within the clause, but overlooking them can cause real uncertainty and result in costly and time-consuming disputes. So it really is crucial to check the governing law and jurisdiction clause in your insurance contract. If it looks anything remotely like the example we've just talked about, then obviously alarm bells should be ringing. But if there's any uncertainty, insurers should be thinking about what they're actually happy to agree. So having looked at what should be in these clauses and how the courts can interpret them, we're going to consider what can go wrong for insurers by looking at another interesting Court of Appeal decision.
So we're going to take a look at the Court of Appeal decision in the 2007 case of Korean National Insurance Co. v. Allianz Global Corporate and Specialty. And this claim presents a unique set of facts and interesting decision making to which the clauses are relevant. For ease, we've included the parties to the claim on the slide on screen. So as you'll see, the claimant was a North Korean insurer, which we'll call KNIC, and KNIC insured a North Korean airline, Air Koryo, under its aviation liability policy, up to 45 million euros. And KNIC was reinsured by reinsurers represented by Allianz, up to the same limit. The reinsurance contract was expressly subject to the law and jurisdiction of North Korea. And in 2005, Air Koryo presented a claim under its policy with KNIC, claiming that one of its helicopters had crashed in North Korea and which had caused losses to an equivalent of 43 million euros. Judgment was entered in North Korea against KNIC for an equivalent amount, and KNIC then indemnified the policyholder and sought an indemnity from its reinsurers. Reinsurers refused to indemnify KNIC, and KNIC then obtained a judgment in North Korea against reinsurers, which it sought to enforce in the English courts. Reinsurers defended the claim, arguing, amongst other things, that the original claim had been fraudulent and that it had been concocted to enable the North Korean government to obtain financial currency from insurers, and that the North Korean judiciary was not independent from the state, and that the judgment had been given purely for the benefit of the government. And so, for those reasons, that it was against public policy for the English courts to enforce that judgment. The commercial court eventually struck out the defence and reinsurers appealed, but the appeal was dismissed, and reinsurers ultimately settled the claim for 40 million euros. And that is it's a very interesting and unusual case, which highlights a particularly important issue for insurers, and that is the need to exercise a real caution before agreeing to the governing law and jurisdiction clauses of countries where the legal system is of an unknown quantity and or where a fair trial cannot be guaranteed. And although reinsurers tried to strike out the claim for enforcement of the North Korean judgment on the basis of concerns with the underlying claim and with the independence of the judiciary in North Korea, those arguments failed. And if the reinsurance contract had stipulated the law and jurisdiction of England and Wales, the outcome may well have been very different.
Thanks, Dan. So, drawing together some of what we've talked about in those cases, we've summarized some of the key takeaways for insurers on screen in terms of what to think about when considering governing law and jurisdiction and how to avoid some of the pitfalls we've discussed. Insurers will inevitably have their own preferences around law and jurisdiction, usually based on the system of law they're most familiar with or the courts that are most convenient, for example, based on language and location. Other considerations may be how and where a successful judgment would be enforced, how developed the legal system is in a particular jurisdiction, the average speed and cost of litigation, and so on. To ensure that those preferences are reflected insofar as possible in any agreement, insurers should ensure that policies contain an express choice of governing law and jurisdiction. The governing law and jurisdiction clause should be clearly drafted to reflect the intention. Insurers should be particularly careful when dealing with governing law and jurisdiction in federal jurisdictions like the US or states incorporating different legal systems like the UK. Insurers should also exercise caution before agreeing to law and jurisdiction in states where there may be unfamiliarity with or even concerns about the local legal system. Now, I think we do have time for a few questions. Harriet Strevens, our senior legal advisor, has been collating those, so I'll hand over to her. Harriet.
Thanks very much, Tom. We have got a couple of questions and we have time to go through them all, which is great. So the first question that I'm looking at is do you agree with the decision in the North Korean case?
Yep, I'll pick this one up. Thanks, Harriet. Ultimately, I think yes. The interesting thing about the case is that governing law and jurisdiction clauses were not really an issue. Reinsurers acknowledged that the reinsurance contract was subject to the laws and jurisdictions in North Korea, but they objected to the enforcement of the judgment due to various concerns with the underlying claim, as I've gone through, and with the North Korean courts. And there hasn't really been time today for us to get into the detail of what those concerns were, but reinsurers are always facing an uphill battle once the judgment had been obtained in a jurisdiction which they had submitted to in the contract. And as we've said, the outcome would probably or may well have been very different if the law and jurisdiction of England and Wales had applied, but it didn't.
I appreciate that, Dan. I'm sure our listeners do as well. What if the clause provides for the governing law of one state and the jurisdiction of another?
Yeah, I'll pick that one up. It's a good question, and it's something that does happen. Although it will obviously usually make sense for the choice of governing law and jurisdiction to be the same, i.e. English law and the exclusive jurisdiction of English courts, as Dan mentioned earlier, they're not always and they don't have to be. The obvious advantage of them being the same is that if a dispute arises, the court hearing the dispute will be applying the law that it's familiar with and expert in. However, the courts are generally prepared to at least consider deciding disputes in accordance with the laws of another country. But this will involve having to instruct a local law expert to then advise the court and explain what the relevant law says about the issues in dispute. Now, as everyone can imagine, that's adding a really significant layer of additional cost and complexity. So it's something that parties would ordinarily want to avoid.
So against that background, what advice, if any, and you may wish not to do so, would you give or consider giving to insurers about how they might prevent the risks that you've been talking about?
It's interesting. I mean, brokers presenting the wording of a policy will obviously always have their client's best interest in mind,
Sure.
but the wording suggested might not always be familiar to or operate in the way that insurers want, as we've talked about. If insurers are unhappy with any policy wording presented to them or at all unsure, particularly where they're being asked to accept law and jurisdiction other than that in England and Wales, they should at least stop and think carefully about what the contract's about. At that point, they should probably be asking themselves, do they know what the foreign legal system will interpret the contract like? How does that system deal with non-disclosure, with fraud? Does it uphold exclusions and conditions precedent? Will the court have regard to any English case law on that specific wording? If the answer to any of those is I'm not sure, they should try or at least consider insisting on English law. If they have to agree the foreign law, they should be taking advice on how it works and or rating the risk accordingly. Similar questions apply to jurisdiction. Are insurers really happy with the jurisdiction proposed by the broker, or should they insist on the jurisdiction of English courts or of arbitration in London or another reputable jurisdiction? If they have a concern, insurers should insist on English law or arbitration wherever possible. I mean, we've seen what a disaster the market's agreement to the North Korean jurisdiction was in the case that Dan talked about. And that's an extreme example. But what we do see is that every day underwriters agree to unreliable jurisdictions. Unless you can be sure of getting a fair hearing in that foreign system, or you're pricing accordingly for the elevated risk, then why agree to it? Insurers can and should stop in those circumstances and just push back. From a broker's perspective, they may perceive that their clients' interests are best served by making the policy subject to the law and jurisdiction of their client's domicile, but it's not necessarily in their client's interests either. Both sides will often get a fairer hearing in England against the backdrop of, centuries of insurance law.
Wow, that's an answer and a half, Tom. I could carry on talking about it for a long time yet, but we like to finish on time as usual, and I'm quite sure we can pick this up another day. But for the moment, that's all we've got time for questions, and I'll pass the baton back to you.
Thanks, Harriet, and thanks everyone very much for joining us this morning.